Welcome to GovCon Intelligence. My guest today is Jayna Rust. Jayna, thanks so much for joining us.
Yeah, thanks for having me. It's great to be out here.
Terrific. Jayna is a partner at Thompson Coburn in Washington, D.C. She advises recipients and awardees of federal contracts, grants, loans, and other financial assistance, and represents them in litigation involving claims and bid protests. She's a graduate of the George Washington University Law School, and she's also an adjunct professor there. I wanted to get started with how we got to know each other. You organized a panel, seems 3 years ago at this point, for the American Bar Association, their public procurement conference, and it was about the Supreme Court's case, the Students for Fair Admissions case. We're about 3 years out from that. That was in 2023, it's 2026, and it's had a huge impact, I think, across the whole country, but particularly in our industry of government contracting. So could you take us back to that case? What did the case say? What were your first impressions of it when it first came out?
Yeah, so it's funny that you mentioned that case because when I've been dealing with a number of things this year with just anti-DEI kinds of things, I think that panel comes to my mind a lot. And I think our panel was in November of that year, but we were planning it as early as the spring of that year, getting ideas for what we would do for that conference. And when we first started planning for that conference, the Supreme Court had not issued a decision yet, but we knew it would come out sometime before the conference. And we thought maybe there might be something to that. And part of why I was pushing the conference to think about it was I remember my third year of law school. By that point, I already knew I wanted to do government contracts because I was a nerd. Who else knows by the third year of law school they want to do government contracts law?
You did go to GW and they have a great program.
Yeah, that is true. That was what led me down that path. But I remember being in my constitutional law 2 course and reading the affirmative action decisions about Michigan and reading them and thinking, all of the cases they're citing are government contracts cases.
Adirond.
Yep, and Croson, those decisions about how federal money should be. And that's what the Supreme Court was thinking about when they permitted the Michigan schools to do certain things. And so once the challenges came up for Students for Fair Admissions, I remember just pinging that in the back of my head of this is a case I need to watch because however this decision comes out, it's going to affect government contracts. And so I had that case on my radar, waiting to see how that would play out. And then we started to get a pretty good idea of how that case was going to come out, even before the decision was issued. But it was issued in June. And I remember, I think that was right around the time when I contacted you and a few others to see if you'd be interested to be on the panel, because we wanted a broad swath of folks, because we weren't sure how quickly the decision would roll down to government contracts. Because the decision was focused on college admissions.
Right.
It was focused specifically on the admissions programs for Harvard and University of North Carolina, and whether or not their admissions programs violated the equal protection provisions of the 14th Amendment of the Constitution. And I think a lot of folks viewed that case as, oh, this only applies to affirmative action in college admissions. But when I was thinking back to my constitutional law class from law school, I thought, okay, yes, that's all the Supreme Court said. But when we look at what was behind all of those earlier decisions, we know it's going to come out.
Sure.
In government contracts. And sure enough, I think we had just started planning when the Middle District of Tennessee, or the District Court in Tennessee, I think it was Middle District, issued a decision involving the AA program. And
It's the ultimate services case.
exactly. And that was less than a month after the Supreme Court's decision in Students for Fair Admissions. And the judge in that case basically said that there can't be the rebuttable presumption based on race that the 8A program had been built around for quite a while. And so by the time we had our panel, it was rolling very quickly.
It's a very well attended panel from what I remember.
Yeah. And it was great because you were able to speak about the federal small business side of things and how it may impact that side. We had another speaker that was able to talk about how state and local governments had implemented various Supreme Court cases that had been cited throughout the Michigan cases and how those may be impacted by the decision. We had the labor employment attorney to talk about the affirmative action from the hiring and employment standpoint, someone to talk about it from finance standpoint. And to me, it was just a great way to talk about all of these things that were going to impact government contractors, from state and local government contractors to people who just employ persons as government contractors to the federal side. So yeah, I really liked that.
I don't do labor employment. That's not an area that I practice in. So I was really interested in what the labor employment lawyer said on that panel. And I remember that there was, to me, this dramatic moment where he said companies need to stop giving preferences for race or for gender because that's illegal. Oh, I guess he's right. That probably is illegal. And it turns out that has been a very big focus of this administration, the Justice Department, not just looking at programs like the 8A program, but also at individual companies and their perhaps previously called DEI programs, diversity programs, their HR hiring practices. Have you seen that in your practice as well?
Definitely. Part of that is my practice does cross over into the government contracts, labor and employment side of things. So the labor and employment issues that government contractors face, which because of the Executive Order 11246 requirements, a lot of contractors would have affirmative action programs related to minorities and women. And after the president's executive order in 2026 last year, revoking Executive Order 11246, I was brought in by a number of companies and universities to look in their affirmative action programs to see what they had done. And it was a bit surprising how many programs had policies that I think would not withstand true scrutiny and challenges.
That's so interesting. Another contemporaneous thought about that case was the footnote was a big deal. It was about the military academy saying this is improper for universities like Harvard and UNC, but maybe military academies, I think a Naval Academy or West Point might be able to make a case for continuing affirmative action practices because of either the diversity of the military or diversity of their student bodies. Has anything happened with that footnote? Does that come up anymore?
I'll be honest, I haven't seen that, but that doesn't mean it hasn't come up.
Yeah, I just wonder if anybody's tried to take advantage of that footnote, but I haven't seen it either. Okay, so let's turn, we mentioned in your bio that you work on grant programs, you work on financial assistance and contracts. What has been the reverberations of the Supreme Court's decision in all of the areas that you work, including grants and financial assistance?
I think after that decision came out, contractors and federal grant recipients started to question whether or not they may have litigation liability for some of their preferential programs, whether it be hiring, whether it be vendors, just any of their programs. And so they started to reach out slowly after Students for Fair Admissions, and a number of those entities, I think, made changes during that time period. But I think when President Trump issued Executive Order 13147, I can't remember the exact number, but the executive order that revoked 11246, to me, that's what just hit the accelerator for it.
Yeah, they're really paying attention to it now.
Yeah, and I think a lot of people like to say executive order was a sea change and completely changed the landscape. And I think it did, but I think it was already moving that way. Companies were already starting to review things in line of Students for Fair Admissions and the other cases that were coming up under it. And taking a closer look at programs, there was already that litigation liability that they might have from class actions, from students, depending if they were universities. But then the executive order, I think, just increased the potential for liability and increased the focus on it. But to me, I'll be honest, I don't know that the executive order changed things that dramatically, given what I think we are already going to see from Students for Fair Admissions, but it would have come out, I think, just through case law decisions and have been a slower point of where we're going to get.
So has that prep after the case been worthwhile? And other way of putting that is, have you seen actions from, say, the Civil Rights Division and DOJ against private companies or contractors for things that maybe were in their programs before and they haven't taken out?
Department of Justice has said they've started those investigations, and there are those rumors out there about which companies have gotten those notices. So I do think there are companies that are getting hit, and they're certainly getting questions from their contracting agencies or funding agencies at the very least, which I think is that first step from potential enforcement down the line from the Department of Justice as well.
There's probably no bigger issue in government contracting than this anti-DEI, at least in small business government contracting, than this anti-DEI push that's been very impactful and probably detrimental to the 8A program, the sledgehammer memo from Hegseth, and then you have these 8A investigations. There'll probably be some sort of rule that comes out from SBA soon. What are your thoughts about that? Based on what you know about the case and what has happened at the Justice Department, do you think that what's happening in 8A was expected, is a natural consequence of that case, or is there something else going on there?
I think it's a little bit of both. And I say that because I do think we were going to see challenges to the 8A program after Students for Fair Admissions. I would have been floored if we had gotten a decade in and there had been no challenges to the program. And I think that the Ultima case is a perfect example of something that had been a challenge even before Students for Fair Admissions had been decided, and just the case starting to have those ripple effects. Obviously, SBA had to start making some review or conducting some kind of review at that point. And to me, it seemed somewhat inevitable that there would be changes to the program. I don't know that people thought there would be the scale of the sledgehammer kind of review. I think people thought it was going to be more of a change in regulation and how programs might be able to become eligible, or small business concerns may be eligible to be 8A entities, but not the let's go after and try to terminate mass numbers of 8A contractors within a month kind of thing.
Yeah, they seem to be moving quickly against 8A. That's a good point about 8A and Ultima. Just two thoughts on that. One is, in some ways, I think the 8A program was lucky that they had the Ultima case, that they made these changes before the administration changed, and that many of the things that the administration would have done, SBA already did in terms of reviewing everybody's social disadvantage and clearing them based on the removal of the presumption. The second is, I've been surprised that it's bleeded outside of 8A. You know, that the sledgehammer video was just about 8A, but when the memo comes out, it's about all small business set-asides. And we have service-able veterans that are getting these notices from Department of War agencies to show their limitations on subcontracting. There was a hearing in the Senate where the witness says, oh, we should just end set-asides altogether. There's no reason to have these at all. What's your reaction to that? Is that something that you anticipated, and what's behind that?
I think part of it, I would say, maybe not anticipated back in January 2025, but maybe if you would ask me October 2025, I think it was more foreseeable, just given that I think the administration has made a lot of change to government contracts and grants with not the scalpel, but the hammer kind of review, and looking at things just as broadly as possible to trim down and forcing industry to come back and say, these are the parts we really need to keep, as opposed to somebody in the administration going through and figuring out what parts to keep.
Yeah, so what do you think is going to happen in the end with the 8A program? I'll just bring up before you answer. I saw an interesting research article this week. It was actually discussed somewhat in the New York Times about what are the biggest issues that the political parties could shift on in order to win more voters. And on the Republican side, I think it was like gay rights. And on the Democratic side, the second most important issue to voters, that where I think the idea is the Democratic Party is farthest away from voters is small business preferences for minority-owned businesses, which is a strange issue to be the second most important issue to midstream voters or median voters. Democrats are reading that, they're going to say, that seems to be an area we should shift away from. So now you have Republicans who are running the government saying we want to diminish the 8A program, and you have Democrats reading these surveys showing there's not really a whole lot of support for preferences for minority-owned or disadvantaged businesses. So where do we go from here with 8A in light of that and students for fair admissions?
I think one of the things we might see, and I think it came up on the panel you were on in 2023, part of it is messaging. And I think part of it is if Democrats want to keep some of that program, those programs they can, but they just haven't provided the public the information about why these programs are good, and they just assume that everybody is going to believe in them without actually confirming that. And I remember on the panel, I think you all had talked about the fact that this phrase affirmative action is used to encompass a number of different things. It was used in the case, the Students for Fair Admissions case, to describe what was happening in college admissions. Affirmative action is very different in the labor and employment context, where it really was intended to mean non-discrimination in employment practices. And I think it is also different in the government contracts space from the perspective of the 8A program and how things were awarded, because most lawyers don't understand preference programs. And if we were to just go pick out any lawyer from any other practice area, for them to be able to describe how the government has these preferences socially and economically disadvantaged individuals, they're probably not going to be able to provide a good explanation for it. And if they can't explain it, how is somebody in rural Missouri, where I'm from, going to understand it and understand the value and the lack of harm to them? And I just don't think they are unless there's better messaging around.
Yeah, that's a really good point. And that if people aren't understanding it, even if they do understand it, maybe it's not something that they support too. So really, what's the point of understanding all of it? One item I wanted to get clarity on, SBA issued this memo saying we're going to try to open up the 8A program to job creators. And they said white men specifically, white men have been discriminated against, potentially they've been victims of DEI, we're going to review their social disadvantage. Just to be clear, you can't also create a presumption for white men, right? If you had a presumption for Black Americans, Asian Americans, Hispanic Americans, and that's unconstitutional, you can't have a presumption on the other side, right?
Yes, yeah. And I think what's interesting is we've seen, even on the labor and employment context, a move away from certain types of bias and things like that, in what cases the labor and employment world is concerned about, and really how that might impact these cases that may be brought by white males who are bringing charges of discrimination. And I think some of the changes from the administration are going to make those claims harder to bring. But also, I think folks thought there might be a flood of cases from white males who were alleging discrimination, and there has not been. And we are more than a year into this administration with these significant executive orders that have been issued trying to, I think, lead white men into bringing certain types of anti or discrimination claims, and we have not seen a flood of them by any means. So it'll be interesting to see how all of that plays out.
That is interesting. And then just on the university side, going back to the original point of the case in college admissions, what's happened there in the last 3 years?
I think it depends on the university, because I think some universities have seen a decrease in the diversity of the pool of their incoming students, and other universities have seen an increase. What is it that you've been seeing from your side of things?
I just saw something that in the really selective universities, as expected, minority enrollment has decreased. I think there's a challenge against Duke because that has not happened at Duke for whatever reason. But then in next tier of state universities is actually increased. And maybe the thought is that those students are just moving down a tier and that it's all collecting there. So they've seen more diversity, at least based on race, at state colleges, for example.
Yeah, and I think what's going to be interesting is to see how people interpret the impact of students for fair admission when universities have been struggling with enrollment for a while. I think universities wholesale have been having certain struggles with enrollment, and they've been looking at ways to increase recruitment generally. So I think even if there are impacts that seem chronologically potentially tied to students for fair admissions, I don't know that we'd be able to say this is a cause and effect, just given the changing landscape of who's applying to college generally, who's been applying to college over the years, who's been choosing to take the route of more trade and technical schools. Because even with the advent of AI now, that's going to impact who's choosing certain colleges and certain paths and careers. And that's happening right now. And who's to say that's not the impact on college admissions versus students for fair admissions? So yeah, to me it's interesting, and I think people are going to try to consistently look at the statistics to just say this is happening or has not happened. But I think it's going to be so hard to look at it in a black box kind of thing.
Yeah, as my teenagers say, Dad, is college a scam? You pay a lot of money. Is it actually worth it? We'll see. Just switching gears entirely, I know Thompson Coburn is an active law firm for estate planning. I took a couple of estate planning courses in law school, but I've only written a handful of wills, and they're mostly just from books. What kind of clients do you have in estate planning, and what, just outside of government contracting, what is the typical sort of advice that a lawyer would be giving to someone who wants to come in for a will or a trust in an estate?
Yeah, so I did not even take any estate planning classes. I think the only trust and estates coursework I did was studying for the bar related to this, because I do think trusts and estates decisions are so closely tied to taxation and an individual's tax situation. I also did not take federal income tax and only learned that for the bar. And I say that because I do think that there's a lot of trusts and estates decisions that are made based on different understandings that don't necessarily tie in with the rest of a person's life sometimes. You go to a trust and estates lawyer, you tell them what it is you want, and that person isn't somebody you call up every single day for problems. Whereas I suspect you, Sam, you have some of your small business clients who, when they run into issues with operation of their business, you're a pretty consistent call. Whereas I did not do my own. My husband and I use an attorney ourselves for our estate planning. And I think that's fairly common for people to reach out to estate planning attorneys to get advice on what's going to be best for their situation. Because we could go online, and even though we did this before the blow up of AI, we could go online, pull down some kind of will and sign it and say, okay, we've got a document now. This says what we want to happen to our assets. It says what we want to happen with our child. We're done. An estate attorney, trust and estates attorney, is going to walk you through what's best for your situation. What is it that you truly want, and how can you get there in a way that probably gives you the least tax impact and gives any person you're giving your assets to the least tax impact. And I think that's usually where that advice
It's primarily taxation.
Coming from. Of what is it that you want, and how do we deal with that from a tax perspective?
Okay, so you're looking at it to try to lessen taxation. You want the assets to go to your heirs without them getting a big tax hit. What happens for government contractors? How do you get involved? What are the big pitfalls there?
Yeah, I think, so I've become involved through some early stage planning for government contractor owners when they are working with their trusts and estates planners, whether it be attorneys or an accountant. They're working through these issues. Sometimes they'll bring me in or be helping them with some of the corporate documents, and these issues may come up But unfortunately, we've also seen situations where an owner of a small business passes away during the time period when they have active contracts. And that's another situation where we do become involved and help them address some of these issues because the SBA has regulations on what happens to contracts when somebody dies, what happens to contracts and the certifications when someone passes away, or how much ownership somebody must have for the entity to be deemed a woman-owned small business, or an 8A, or a service-disabled veteran-owned small business, or any of the other similar types of programs.
Oh, we have a lot of cases in the veteran-owned space on these sort of issues, trusts in particular. There's a case about tenants by the entirety that came out recently. And I want to clarify that the reason that they're in the veteran-owned program is that you can appeal a decline in the veteran-owned program. You can go straight to the Office of Hearings and Appeals for veteran-owned decisions. You can't do that for women-owned. You can't do it for HUBZone. You can do it for 8A, but that just happens less often because people spend a lot more time on their 8A applications, whereas with veteran-owned, it's hard to do that. So what have you been seeing in these cases on the veteran-owned side?
And it's interesting you point that out because oftentimes we'll look at what decisions are out there when we're providing counseling to clients on these issues of, regardless of the type of program that the client has a question about. When it's the ownership questions, we'll look at what else is out there to see if we can pull threads of how SBA is going to look at things. And because the SBA regulations require contractors to be owned by an individual and directly owned by the individual, it becomes really relevant of how the ownership is set up. And what we see is how the SBA has interpreted the provisions of whether or not a trust is an acceptable way to have direct ownership. Because a trust is not direct ownership. If a trust owns the company, Small Biz Co., and a trust owns that, it's not directly owned by Jayna Rust. It's owned by my trust. And SBA said, okay, there's going to be some ways we'll accept the trust. But there's really 3 essential requirements for the trust to meet that element of being direct ownership. And it has to be the grantor, the trustee, and the beneficiary all have to be the same individual, and it needs to be a revocable trust, which is something that a lot of trust and estates planners don't understand. I don't want to say don't understand, but they can't wrap their head around because it doesn't make as much sense from a trust and estates perspective.
Yeah, that probably has tax consequences as well. Before we wrap up, I wanted to ask you about your course at GW. You teach a course on claims. What are your biggest practice points for students in the course? And what's the difference between getting into government contracting on the claim side versus, say, bid protests or small business? What makes a good claims lawyer?
So it's interesting. I think one of the things that makes a good claims lawyer is someone who loves digging into the facts and really digging into the documents. And I think a lot of law school students, even though the class I teach, is a lot of JD students, as it also has a lot of LLM students, so students who are practicing lawyers who may just want a degree in government contracts. But I think something that surprises students is how fact-heavy claims are versus protests. Protests are so document-heavy, and it's very document-heavy on the claim side as well, but there's a lot more gaps in the claim side that matter. Because on the protest side, it's generally what did the solicitation say, what did the evaluation document say, is there support for the agency's decision? On the claim side, it's a lot of what really did people know? What was really happening? What was the state of the hole in the ground? And you're gonna have to maybe even go out and take a look at the hole in the ground and to see if that was truly a differing site condition. And I think I don't want to say needs to be more curiosity, but I think the students who really dig into the facts and enjoy them and enjoy getting to know what's happening tend to do really well. But there's also just, I think, the need to have a lot broader ability to issue spot on the claim side. Because there's all of these issues that the client is coming to you with and saying, these are the problems we're having. And there's, I think, a bigger pool of arguments that can be made from the claim side of whether or not things are right, but also then knowing what do you get even if you are right. Okay, I went on this argument legally, but do I get more money? Do I get more time? If all I get is more time, is that really going to be enough for what my goals are?
That sounds more like being a real lawyer instead of what we do. Jayna, how do people find you?
They can find me online. I'm on LinkedIn. If they want to reach out, they can certainly reach out. Just let me know how you met me or how you saw this. But they can also find my information on the firm's bio.
Wonderful. Jayna, thanks so much for joining us. Thanks, everybody.